Hello everyone and welcome. Thanks for joining us this afternoon. My name is Gerald Fahy and I'm joined this afternoon by two of my colleagues, Paul Ball and Georgia Horrocks.
Hello.
We are employment law specialists and part of the Gateley Legal business based in Leeds. Firstly, I'd like to thank IOSH Yorkshire for hosting this webinar this afternoon and for inviting us to speak to you. It's fantastic to see so many of you join us. We'll firstly take you through some of the key aspects of the job retention scheme, also known as Furlough, and then we're available to answer your questions. So really we're in your hands essentially from that point. We'll aim to deal with as many of your questions as we can in the time that we have. Before we begin, just a few words about the Furlough scheme. Furlough is a new concept in the UK. Its origins are actually in the Dutch language, and it roughly translates as leave of absence. The term is most often used in the US and came to prominence during the financial crisis in 2010. Since announcing the scheme, HMRC has published guidance on a number of occasions. So from the first guidance on the 26th of March, we've had 5 additional updates to the guidance. Guidance is, however, just guidance, and when considering how any legal rights and obligations should be exercised, it's the legislation that underpins the scheme that will take precedence. In this case, the legislation takes the highly unusual form of a Treasury direction. The fact that there have been so many updates to the guidance and a delay in the legislation has, to say the least, been very unhelpful and has kept us as employment lawyers very busy indeed. Our aim today is to clear up some of the confusion and to answer your questions. So over to you, Paul.
Thanks, Gerald. So first sort of top 10 point relating to the coronavirus job retention scheme is originally announced on the 20th of March, backdated to the 1st of March and due to be in place for 3 months. And the government announced at the time it may well be extended, and it already has been extended. You'll have seen that news in the last few days. The scheme now is going to be in place until at least the 30th of June. Possible further extension. Your guess is possibly as good as mine as to when that may be. Difficult to know whether we are at the point yet where we are going to be able to start returning to work, but the scheme is going to be in place for a minimum of 4 months now, may well continue beyond that into September, or certainly into the summer period. Okay.
The next key point is that the 2 key dates are the 28th of February and the 19th of March. So the previous date that employers were working towards was the 28th of February. However, when the direction was published last week, it changed the relevant date to the 19th of March, which is the date before the scheme was announced. So the key point for either of these dates is that to be furloughed, an employee must have been on the employer's PAYE system at the relevant date, and the employer must have submitted an RTI, which is a real-time information submission, which confirms that they were on payroll at that time.
Thanks, Georgia. Shielding employees. Well, shielding is a way to protect people who are extremely vulnerable from coming into contact with coronavirus by minimizing all interaction between them and other people. Some people, including children with long-term lung conditions and similar, who are at very high risk of severe illness from coronavirus, have been advised to rigorously follow shielding measures to keep themselves safe. So people who are extremely vulnerable have been advised to stay at home at all times and avoid any face-to-face contact until the end of June. The government is monitoring this position regularly, and this is seen as the best way to protect people who are at particular risk of serious complications from coronavirus. So with that in mind, how does this impact on employees who are shielding? Well, the guidance says that employees who have been advised to shield may be placed on furlough. Concerns were raised that the legislation states that an employee may not be furloughed whilst entitled to SSP. So to cut through some of this, we think the way to look at this is to ask yourself two things. Firstly, is the employee shielding because they are sick? If they are, they should be paid SSP. Or is the employee shielding but fit for work, or shielding because of a vulnerable family member? If yes, they can be furloughed. Over to you, Paul.
Thanks, Gerald. So the minimum period that an employee can be placed in furlough for is 3 weeks. And that's not to say the period is only 3 weeks or it's multiples of 3 weeks, but it has to be for a minimum consecutive block of 3-week period. So that means that in theory, you could have an employee placed on furlough for 3 weeks. Then if it came to, for example, a month-end piece of work that was required to be done, they could be brought back into work and then placed on furlough once that piece of work is finished. As long as that second period of furlough is at least for another 3-week period, there's no reason why you wouldn't be entitled to claim payment under the scheme for both of those periods. That's also not to say that the period has to be at least 3 weeks, it has to be only 3 weeks and can't be any longer than that. There'll be many cases where employees have been furloughed from the earliest possible date, maybe 1st of March, and will remain furloughed up until the scheme is no longer in place or the employer otherwise brings the situation to an end, which could be several weeks beyond that, but it has to be multiples of 3 weeks or a minimum of 3 weeks. Georgia.
Thank you. So the 5th point is that employers must confirm furlough in writing to the employees and keep a record of this communication for 5 years. This can be in electronic form such as email, so it doesn't have to be a formal letter or written agreement. It can be simply confirming over email, but the employer must have instructed the employee in writing to cease all work for that employee. So the employee cannot do any work during that furlough period. Gerald?
The government contribution as part of the grant is 80% of gross wage costs, up to a maximum of £2,500 per month per furloughed employee. In terms of how that is calculated, this really depends on the type of contract that the employee is employed under. A full or a part-time employee on a salary will have an entitlement to 80% of their monthly salary as at the 19th of March. Where an employee has variable hours or their pay varies from month to month, the amount payable will be calculated by taking the earnings from the same period from the previous year, or if higher, an average from the 2019-2020 tax year. If the employee has been employed for less than a year, you can claim for an average of their monthly earnings since they started work. Employers should and can include in the calculation all regular payments from the employer, or that the employer is obliged to pay to employees, including past overtime fees and compulsory commission payments. One final point is that the government under the scheme will also cover employer insurance and also compulsory employer pension contributions on top of the £2,500 contribution. Paul.
Thanks, Gerald. So one thing that's been raised quite a lot with us is how much employees are paid when they're on furlough, where their salary may be higher than the maximum amount that will be paid for or covered under the scheme. Well, the highest amount that the highest salary that will be fully covered at 80% level under the scheme is £37,500. Where you have employees who are paid more than that, and they agree to be furloughed, bearing in mind that placing somebody on furlough has to be with their agreement and cannot be imposed on them. If their salary is higher than this £37,500, your contribution has to be your salary payment you make to them, pardon me, it has to be the same as the salary they would normally receive, unless they also, at the time of being agreed to be placed on furlough, they agree to accept a reduction in their salary. If you simply furlough them and reduce their salary to the amount that is you would recover under the scheme, you're potentially making an unlawful deduction from wages or a breach of contract, and you're saving up either the risk of a constructive unfair dismissal claim or an unlawful deduction from wages claim in due course. So you have to bear in mind that whilst you might be able to claim salary costs up to 80% or up to a maximum of £2,500 per month for employees who are furloughed, to the extent that there's a shortfall between that and the employee's normal pay, then unless the individual agrees to forego that and to waive that salary, that's an amount that still has to be paid by you. Georgia.
Thanks, Paul. So Geralt briefly mentioned this in his last one, but for point 8, the government, so they will cover 80% of the gross wage of the employee, and they will also cover the national insurance contributions on that 80%, as well as employer pension contributions, which is the compulsory minimum amount of 3%. So all those can be recovered under the new scheme. Thanks,
Georgia. And an important consideration for all of us is holiday and holiday pay. This has been a problematic area and one that largely seems to have been avoided by the government in the guidance. What we do know is that the guidance has been updated to include references to holiday pay. So this confirms that an employee can take holiday whilst on furlough. This reflects what the ACAS guidance says, and as an extension of the government and regarded as a government body, then this is important. ACAS says that furloughed workers can request and take their holiday. It also suggests that an employee may be required to take holidays. So this is what we would, as employment lawyers, have expected, because it brings into play existing rights under the working time regulations, which allow an employer to require an employee to take their holidays. I think this must come with a health warning, however, and employers shouldn't view this as a green light to force employees into taking lots of holiday during a period of furlough. That may well be unlawful. Some modest and agreed holiday would, however, likely be permitted, including the bank holidays. They fall due both Easter period and as we get into May. There's one other point just following on from that, which was reference to, or an extension to, the holiday pay year. So there's some confusion around this in terms of whether or what the intention behind this was, but some of the commentary that I've seen suggests that this was actually included with a view to really with key workers in mind. And the obvious issue is that with the tremendous work that has been done by key workers, then there's no obvious point at which they can take their holidays, or they would have a reduced period in time over which to take them. This, we believe, is the reason for the extended 2-year period instead of the usual 1-year period in which to take leave. From an employer's perspective, of course, then if an employer doesn't want to extend those holidays, then they don't have to grant a request to extend. But it's just really to make sure that is there and the reasons for it. My last point on holidays, last but not least, the ACAS guidance does say that furloughed workers must get their usual pay in full for any holiday that they take. So, in other words, if someone is furloughed up to the maximum available under the grant, then if they choose to, or the employer requires them to take holiday, then they should receive their full pay as instead of the furlough pay, or in other words, the employer is required to top up that pay to their normal pay. Paul.
Thanks, Carol. So the portal opened yesterday morning, and as at yesterday lunchtime, these were the stats that we had. Employers had made 67,000 claims in the first 30 minutes. By the end of the day yesterday, 185,000 firms had submitted claims covering 1.3 million employees and a likely payroll cost to the Treasury of £1.5 billion. So quite clearly there has been a significant uptake of this. I can anticipate that's likely to continue for the duration that the scheme is in place. One thing that none of the three of us are really going to be able to deal with today is any questions relating to how the portal is operating. That's something really that is a payroll or accountancy type question. We certainly can answer as many questions as possible regarding entitlement to furlough and so on. If people do have any portal related questions, we'll try and keep hold of those, and we may, if there's sufficient interest, run a webinar separately on this with accountants to deal with portal related queries, but we're hoping to focus now on queries about furlough, and I can see already from the Q&A box quite a few questions have been raised, so I think we should just launch straight into those, bearing in mind where we are on time.
Yep, thanks, Paul. So what I'll do is I'll be looking at the question box that you're all posting. Thank you for those. We've got quite a few already. And pose those to you, Paul, and you, Geralt. So the first one that we've had in, please can you confirm that furlough can go for 2 weeks and then you can have a week at work, and that 3 period completes the furlough?
Yeah, I'll deal with that one, Georgia. Linking back to one of the earlier slides, that's not the case. Furlough has to be for at least a 3-week period. If you cut furlough short and bring somebody in to do some work within that 3-week period, then you will not be able to claim any payment in respect of the entirety of that period. It has to be for an unbroken block of at least 3 weeks. People can do voluntary work not for the organisation. They can attend training. But they can't do any sort of economic work for the employer within that 3-week period.
Thanks, Paul. Another question for you guys. What reasons might an employer refuse to re-employ an ex-employee so that they can be furloughed, and how best could they be persuaded to change their mind?
This has been one of the most troublesome areas, I would say. I think each one of us has come across this in one shape or form over the last few weeks. I mean, we're employment lawyers. We spend 95% of our time advising employers, and my response to this and the advice that I have provided and the approach that's really been taken by certainly my client has been, well, really, why would we want to? Why would we want to do this? In that someone has left your employment, they chose to go elsewhere, or their employment is terminated. Re-employment re-employment has been, it looks straightforward enough, but actually it's really rather complicated. This, I don't know if anybody saw the comments of Martin Lewis, but Martin Lewis, the money saving expert, was proclaiming this as a right, and that everyone should be asking for this. Well, that's fine, but it does open a whole host of issues and poses risks for employers that need to be managed. And for that reason, without going into the detail in terms of how it is that you would manage that, the most straightforward advice is, why would you do that? And to avoid that, that type of scenario. Does that answer the question, Georgia? Yes,
perfect, thank you. Just moving on from that one then, we've had another question in, whether people who have a shielding family member are meant to shield as well. The NHS letter says that the rest of the family can continue as normal, and I guess that ties into then if they are shielding, whether they are on furlough.
I'm happy to pick that one up as well, Paul, because again, it's something that I covered off in the introduction. Yeah, I mean, shielding, I've yet to see a shielding letter. but I've been told lots about them. Shielding has been a troublesome issue, but like furlough, it's a word that has been much used over the last few weeks. I think the short answer is that the guidance is pretty clear on this, Georgia, that if you have a shielding family member, in order to protect your family, then you can be furloughed. So that, to me, is the common sense response, and thankfully that's been confirmed.
Thanks, guys. Next question is, can furloughed staff continue with online training?
I'll deal with that one. Yes, it can. Where you have, one thing just to be aware of is that whilst you're furloughed, if your employees are paid minimum wage rate or slightly above the minimum wage rate, the 80% can take somebody below the minimum wage because they're not actually working. However, if somebody is participating in online training, for the time they spend doing that training, they do need to receive at least the national minimum wage rate.
Thank you. Another one's come in just in relation to this 3-week period. So technically, a furloughed employee can be furloughed for 3 weeks, come back into work for 4 hours, and then technically go back on furlough.
Well, is the question, can they do that? If it is,
yeah.
Then yes, but the day that they've been back in work would not count as part of the furlough period, and there'd need to be a further full 3-week period before the second period was one that could be claimed, the employer could claim under the scheme.
Can you just repeat the question, Georgia, because just so I understand it properly?
Yes, so the question was, if an employee is furloughed for 3 weeks and they then come back into work for merely 4 hours, and can they then be put back on furlough for another 3-week period?
So that if the question is around whether someone would need to come into work for those 4 hours and then be re-furloughed, then yes, but just to clarify that it's not necessary for someone to come back after 3 weeks to then go back on furlough for a further 3 weeks. You could be furloughed for a continuous period.
Yeah, agreed. The next question is in relation to bank holidays, which I guess since we've just had 2 and we've got 2 more coming up, is what everyone's wondering. So when an employee is furloughed through a bank holiday, is the bank holiday payment at 80%, or does the employer have to make adjustments for 100% for that day?
We think that holiday pay should be topped up. So for those bank holidays, that they are part of your holiday entitlement. If you look at the statutory minimum, even it's so many days plus your statutory bank holidays. So yes, I would say that those are days where your pay should be topped up to the full amount.
And just in relation to topping up as well, if an employee has had their wage topped up voluntarily by the employer, can the employer then require that employee to undertake any work during furlough?
Absolutely not.
No.
I think because that would certainly disentitle the employer to then make a claim under the grant. I think lots of businesses have topped up, but the guidance and the legislation are crystal clear on this work point. It's very, very clear, no work.
Mm-hmm.
Just another question, which I know we've been dealing a lot with our clients at Gately, so might be quite a prominent one. Do employees have to accept being furloughed in writing? I know this has changed almost daily over the last week, so this would be a good one to clarify, guys.
Maybe one you could answer, George. but maybe Paul.
Yeah, well, you need to have the agreement of the employee. whether that means individual agreement from every single employee is really a matter of debate, and I think the answer to that is not necessarily. For example, if you're a unionised environment, you can reach agreement with the unions to enter into furlough arrangements with employees, and that will then be an agreement that is binding or accepted by all of the employees. That's the whole purpose of collective bargaining. It avoids the need for individual consent. I think the other point is where if you don't have a collective bargaining type situation, it's enough to evidence that you've communicated the furlough arrangements to the employee and sought their agreement. And unless there's any compelling evidence the individual has not accepted that is the case, the fact that furlough has then occurred and employers accepted any reduced payment that is made on the back of that, I think in many cases would be treated as agreement. But it's not just a question of being as bold as either saying there's a union agreement that's binding, or they didn't complain about it, therefore that's a binding agreement. There's many ways in which you could seek agreement other than asking employees to sign and return a letter confirming that they've accepted furlough status. For example, you could ask for SMS responses or WhatsApp group responses, or indication of any problems with that to contact you by a particular date, and if they haven't done so, then they're deemed to have accepted it, and so on and so forth. So the ideal thing, of course, is to get evidence of individual agreements having been obtained, but we understand and accept that isn't going to be achievable in every single case. As long as you've got evidence of having communicated what furlough means and the date that's going to be commencing to the employee, and given them the opportunity to raise any particular questions or objections to that. If you haven't practically been able to get their formal agreement to that, I think that will stand you in good stead in the event of any challenge by the revenue in due course that you haven't got their individual agreement.
I mean, just to add to that, I agree with all of that, Paul. Just to add to that, it was the Treasury direction. It's quite a mouthful, isn't it? It was the Treasury direction that the hair running towards the end of last week, which then led to some challenge from the CBI, and it was, I believe, since confirmed that what is required is for there to be an agreement, and the agreement doesn't necessarily have to involve that signed consent, as you suggested, Paul, in terms of whether something is signed, an email, a text message. As long as there's evidence of agreement, that should be sufficient. So I just thought I'd just add that.
Thanks, Gerald. And we've had quite a few questions come in regarding redundancy. So one is, I'm currently on furlough, can my employer make me redundant? Another one, does furlough allow for easier redundancy after this period is over? So I wondered if you could just cover off the redundancy points, and also about collective consultation elements as well.
Okay, let's perhaps take those one at a time. So the first question, can you be made redundant whilst you're on furlough? The answer to that is yes. And a period of furlough can also count as a period of notice. Whether or not an employee would be prepared to accept a reduced amount of pay, capped at the amount that the employer is able to claim under the scheme as equivalent to their notice pay, I think is a completely different question, of course. I think very few employees would be willing to forego their normal pay during their notice period in the event they're made redundant whilst they're on furlough. But to answer that question, the answer is yes. I think the second question, Georgia, was around how redundancies might be carried out on furlough. Could you just clarify that, what the question was again, please? Just
does it allow for an easy redundancy process?
Do you mind if I answer that one as well?
No problem, Paul, you're on a roll.
I think the answer to that is no, it doesn't necessarily make it an easier redundancy process, because you may have placed employees on furlough without necessarily having gone through any kind of selection process or selection criteria, simply done it on the basis of cost, on the basis of ease, or without there being any kind of criteria applied. If there is a subsequent redundancy situation that arises, normal rules of fairness around things like consultation, around applying or giving thought to pools for employees for selection, applying selection criteria, and things like that will still apply. So unless that happened prior to employees being placed on furlough and the employer has when it reached decisions as to who to furlough, it did it on the basis of that kind of selection process. Any subsequent redundancy that might arise would really stand or fall in terms of fairness based on what the employer did at that time, rather than what it had done prior to making the decision to furlough employees.
Yeah, I mean, I think just to add to that, it's always going to be a difficult one for an employer if called to defend employment tribunal claims where, let's say, for example, the staff who were made redundant, all of the staff made redundant happened to be all of those who were placed on furlough, and those who weren't. And that's going to present a challenge. I think in terms of a process, it's always going to look much better and be evidence of a fair process if there is a mixture of those who were on and those who weren't on furlough, if that is the case.
Thank you. The next question is in relation to the payment. So we're having quite a few different questions on that. The first one is whether the 80% includes shift allowance or not.
So the amount that is to be used as a method of the base of the calculation is the employee's normal regular wage, with the reference point, as Geralt said earlier on, either the same over the previous 12 months or the same month last year. If a shift allowance is paid because of it's a regular pattern of that individual's working arrangements, or regular part of their working arrangements, then that is something that would need to be included. The very nature of a shift allowance would suggest that in most cases it's part and parcel of their normal take-home pay, because their pay will vary according to what shift that they are working at any given time. So I think the answer is that does need to be included.
Thanks, Paul. Just looking at another one for you that I'd seen. So just to confirm, I've understood the point about the 80% pay. If the employee's salary is over £37,500 gross and they haven't agreed a pay cut, should the employer still pay the difference up to the full salary?
Well, I mean, just to, I think I can pick that, Paul. I think it's a easy one just to deal with, in that essentially depends on the employer and whether the employer has chosen to top up. Otherwise, it's payable up to a limit, and that is the extent of the payment to the employee.
Well, I'll sort of reinforce that and go a bit further on that one, G, if you don't mind, which is that the amount you can claim under the scheme is absolutely at the cap. But if the employee's salary is higher than that and they have not specifically agreed a reduction in that, if the employer only pays the amount that they get from the grant, from the government grant to the employee, and that leads to a shortfall in the employee's normal take-home pay compared to what they would have been paid had they been working as normal, we say there's a risk, therefore, that there's an unlawful deduction of wages being made because the employee hasn't expressly consented to a reduction in pay. So if you're putting employees on furlough and you're wanting them to accept a reduction in pay, the two things need to be expressly stated in the furlough agreement, rather than simply asking the employee to agree to be furloughed and you assuming that it's understood by the employee that means they're only going to be paid the amount that you can claim from the government.
Yes, that makes sense.
Just a simple question for you guys. Will I get a pay slip from my employer during furlough?
I think the answer to that is yes.
We're having quite a few different questions, a few different people asking the same question, which is what happens if an employee refuses to be furloughed?
I suppose the question is if the employee refuses to be placed in furlough, or if they're refusing to accept a pay cut as part and parcel of being placed in furlough. If the employee refuses to be furloughed and the employer has no work for that individual as a result, then there's potential redundancy situation unless the employer has got a layoff and short-time working arrangement in its employment contracts. So an employee refuses to be furloughed is entitled to carry on being paid as normal unless and until the employer does something about it in terms of redundancy consultation and making that individual's role redundant.
Yeah, I mean, we have to go back to the purpose of the job retention scheme, and the intention of the government was to avoid potential redundancies. And so the only alternative, I agree with you, Paul, the only alternative in that type of situation, Georgia, is that the employer would be forced to look at cost-cutting measures, including redundancy.
I agree on that one. The next question is, if a person is furloughed, can they work for another company and receive pay from that company?
I'll deal with that one. If you as the employer are happy with that to happen, then yes, there's nothing to stop that. And the guidance has been clear on that, certainly since I think the second version of the guidance, that an employee can work elsewhere during a period that they're furloughed from you. That said, I do know of several employers who, when they've placed or asked employees to agree to be furloughed, they have said to them, you are not allowed to work elsewhere. That's typically been the case where the employer is topping up the salary so that the individual perhaps is carrying on receiving normal pay during any period of furlough, but where they might want to call the employee back in from furlough on short notice. They want to know they've got the ability to do that, and the employee will return to work promptly. But no, there's nothing to stop an employee from working elsewhere if you are happy with them to do so.
Thanks. And Paul, I'm just going to put this one onto you because I know we dealt with this the other day. If you did re-employ someone, what would happen after this quarantine ends? So would they have to resign again? And are they owed notice, holiday and pension contributions as well?
Yeah, well, this is I guess that's clarified some of the kind of issues that Geralt mentioned when the question was raised on this point before, that if somebody who has either resigned and left within the relevant window or been made redundant and is asking to be re-engaged. And first of all, I have every sympathy in that situation where they might want that, particularly if the work that they were going to go to has not been able to commence because of this situation. I have sympathy for the individual, but at the end of the furlough period, or at the end of the government job retention scheme, or when the employer decides that other action needs to be taken, that individual who's being re-engaged is still an active employee and has to be, the issue has to be addressed. So it's not simply a case of their employment will automatically come to an end at the end of the furlough period. If the employee would either have to resign, or there would have to be a dismissal. If neither of those things happen, the individual would continue in employment with you and subject to rights of salary, accruing holiday pay, pension contributions, etc. So if you are looking to or might be considering re-employing somebody specifically for the purposes of furloughing them, and claiming payments under the scheme, and you can do that, I think it's really important to be clear at the outset to the individual that there's no continuity of employment. So the date of commencement of new employment is the date that they are re-engaged by you without no retrospective effect. Also making it clear that their employment is specifically for a fixed term and only for such time as you are able to claim payments under the coronavirus job retention scheme in respect of that person. And that as and when you are no longer able to claim under the scheme, or you decide that you're not going to claim under the scheme for that person, then their employment will automatically come to an end. If you want a complete belt and braces approach, you would also make the offer of new employment conditional on the individual entering into a settlement agreement in which they agree that on the future termination of their employment, i.e. at the end of the furlough period, they won't try and bring a claim for things like accrued holiday pay or things of that nature that may have arisen during the period of furlough. I'm only addressing a few of the points here that are a number of the reasons why Geralt, myself and Georgia all think there's quite a lot of practical barriers, legal barriers, as to why the re-engagement of somebody who's otherwise been terminated or resigned simply for the purposes of furloughing them is actually potentially going to create a lot more headaches than you might anticipate, and therefore only think about doing it as a last resort or with a great deal of caution.
Yeah, sorry to give you only 2 minutes to answer that, Paul, when we've been doing our calls on that one. Next question, does the employer need fresh furlough agreements from the employee at the start of every 3-week period?
No.
Nice and simple.
Nice and simple, yeah. Try and get questions, but no.
Another one then, would my normal notice period apply under furlough if I found alternative employment?
Yes.
Your short answers are just giving me time to find the next question for you. So this is more
this
in relation.
This is going to be a difficult one.
Yeah. This we're having quite a few that are more in relation to the portal, but there's a few that are saying that employers are only claiming 3 weeks of an employee's furlough salary, but they might have been furloughed for 4 weeks. Can you answer that one? I assume it's just because you can only claim for 3-week periods, maybe, or?
Yeah, I think it's, you can make a claim once every 3 weeks. So I think the idea is that you do make a claim once every 3 weeks to cover 3 weeks of furlough for any given employee.
And in advance of the payroll, because the process seems to be set up then to deal with pay for that month and for that payroll. But once you get into a cycle, then it should run through.
Thanks, guys. The next question that I've just seen, what is the latest date that furlough may be accepted?
I'm not aware there is a latest date on that, to be honest, Georgia, because the scheme is in place until the end of June. We don't know whether that means that payments won't be made in respect of a period of furlough after the end of June or not. We haven't got that kind of clarity. If it is the case that the government does cut off the scheme at the end of June, it would suggest that the last date that somebody can be furloughed and receive payments in full will be 3 weeks before that date.
Yeah, I agree with that.
9th of June. My mental arithmetic a bit slow there.
We're having quite a few questions on SSP. So this particular one is if someone was showing COVID symptoms, they would likely to be placed on SSP, which then proves a potential conflict with someone not raising it because they're already on furlough. They've not set out the particular question, but I guess if you are already on furlough and then would be showing signs of COVID, do they have to come off furlough and go on to SSP?
No, that's been confirmed, Georgia, in that if you're on furlough, then it's not necessary then to come off furlough to claim SSP. You're permitted to remain on furlough.
Thanks, Gerald. Another one that's come in, do you need to be does the employee need to be proven to have made redundant if the furlough scheme had not been introduced in order to claim the furlough payment?
I can answer that one, Gerald. One of the earlier guidances was a bit controversial and contradictory in that it said that you could furlough somebody in certain circumstances and if they would otherwise be made redundant. That if they would otherwise be made redundant wording has been removed from the latest versions of the guidance, thankfully. So I don't think there is a strict requirement that for somebody to be able to be furloughed and for you to be able to claim the grant. It is a situation where they otherwise were going to be made redundant. It's simply of, are you furloughing them because of COVID-19 and the impact on your business, and have they agreed to be placed on furlough rather than they would otherwise be redundant?
Thanks, Paul. We've had a couple of questions in relation to limited companies and also other situations where the job retention scheme might apply. So can you explain whether the job retention scheme applies for A, self-employed people, and B, directors of limited companies?
This scheme is not the scheme that's in place for self-employed people. This is for employers to have in place in respect of people who are its employees rather than people who are self-employed. So it's not for those who are self-employed. In relation to those who are company directors and who perhaps might be on payroll for the purposes of the tax-free allowance, with the bulk of their earnings being paid by way of dividend, they can only claim their 80% of their salary on payroll, not 80% of dividend payments that might have historically been made to them under the scheme. And we haven't had any announcement made of any other support that is going to be made for company directors in respect of what their normal earnings might be and protection for dividends or compensation for unpaid dividends. In the same way that we have had this for this scheme for employees. With regard to self-employed people, I'm not aware yet we've had the details of the scheme in terms of the precise mechanics, but what has been announced is payment up to, for similar level, up to those for employees under the scheme. We haven't yet got the arrangements in place for those claims yet to be made.
I think self-employed people should be expecting a letter specifically to them as to the payments that they can claim rather than claiming on a system like the employees are doing on the job retention scheme. We've had quite a few questions in on one of the points about shielding, which Gerald, I know you covered off during our top 10, but maybe you could just go back over some of the points. The specific question is, with regards to an employee who is shielding because they are over 70, what is your view on the payment position?
Well, if it's that if that individual is an employee and they are not, then they can be furloughed. If that individual is a family member of an employee, then that employee can be furloughed on the basis that they have a family member who is shielding.
Yeah.
Thank you. Just trying to find some more questions. We've got 62 still unanswered, so there's still quite some more to work through.
That's quite a challenge.
Just trying to find some different ones that we haven't already covered off so that the participants get as much out of this as possible. Will furloughed employees be at a disadvantage if they were the ones chosen to be furloughed with potential redundancies at the end of the scheme?
I think the answer, I'll just take a little bit, Jean, and if you've got anything else to add, is that okay?
Yeah,
I think in answer to one of the earlier questions, George, on this, I think that it's simply using furlough as a basis to determine who should be made redundant in due course, where the employer might face a subsequent redundancy situation, would be problematic, because furlough isn't, decisions on who to furlough and who might be on furlough could be taken for a variety of reasons. It could include, the available work, but it also might include the individual's personal circumstances, self-isolating because of a family member, difficulties with childcare and school-aged children, for example, a whole variety of reasons. None of those are fair reasons for selection for redundancy. So I think if you were to use furlough as a basis, and an unfair dismissal claim subsequently arose, you would have some challenges to show that was a fair criteria.
Yeah, I mean, I don't think there's a lot that I would add to that, Paul, except really to say, in answer to the question, you shouldn't. And I agree with you that you would have some difficulty in resisting claims if that were if that were the basis for the decision to furlough.
Another question for you guys. I have a monthly car allowance. Will this continue to be paid during furlough?
The answer is that your employer should carry on paying the car allowance, and unless they've specifically asked you to forego it, and you've agreed to forego it, because it's normally something that forms part of the contract. It's a different question as to whether that can be claimed by the employer under from the government under the scheme, and I think the answer to that is it can't. I think that's the answer to that, but certainly that's something that your employer should continue to pay to you unless you've specifically agreed to forego it.
Thanks, Paul. Next question. If a member of staff has agreed to furlough and been told their pay will be topped up, but then after a few weeks the employer decides not to top up the 20%, does a new agreement need to be made between the employer and the employee? I
would say that, Georgia, you're essentially renegotiating the position. I think you would, at the very least, you want to inform that person, because their decision as to whether to be furloughed or not may well be different, if not likely be different. So I think that would be the sensible approach.
I think that's right. Absolutely. And if the employer simply says, as of next month, you are now going to get 80% of your pay rather than 100% of your pay, for example, take furlough out of the equation, you wouldn't be particularly happy about that, and it would be an unlawful deduction from your wages. A furlough doesn't really make any difference to that. So unless you've got specific agreement, i.e. a new agreement and a renegotiated furlough agreement, the employer that does that does run the risk of employees claiming unlawful deduction from wages in due course. So I'd be careful about it.
Yeah. The next one's in relation to furloughed and non-furloughed staff. So if an employer has furloughed some of their staff and those employees are on 80%, so the employer's not topping up, but then the employer has also asked those who are remaining in work within the same business to take a 20% pay cut. If that takes them below the national minimum wage, what are the consequences of that?
So this is people who are still in work and not being furloughed.
Yeah.
They'll have to be paid the minimum wage. You can't take their pay down below the minimum wage. However, as I said before, I think people who have been furloughed If the 80% figure takes them below the minimum wage, then that's fine for the period that they're furloughed, unless they spend any time doing training for the employer, and in that period of time, they have to be paid at least the minimum wage.
Yeah.
I've just got one point that's cropped up going back to the redundancy questions that we had a little bit earlier, but it's a bit different, so I'll ask you guys this one. So this particular person is in a team of consultants who all do the same role, and half have been furloughed with the salary topped up. No process of selection was shared. And then, so they've asked, if we are furloughed again beyond this date and no top-up is offered, should a rotational process be adopted to ensure a fair distribution of pay?
I mean, I think that rotation is certainly something that we've seen quite a lot of.
Yeah.
Sometimes on 3-week blocks. There are good reasons for that. And you know, the one thing we haven't touched on today at all is some of the effects for employees on being furloughed, and then the consequent effects for the business. And really what I'm getting at is on mental health and the isolation that it can cause individuals having been furloughed. So purely from an employee relations perspective, then that is something that you would want to do, and to encourage others to share some of that load.
Yeah,
I agree with that. Another question that's come in, is it legal to be furloughed when you are working from home and still have work to do at home?
Well, I'll answer that one quickly, G. I think the answer to that is it legal to be furloughed? Well, you can only be furloughed with your agreement. And so if the employee hasn't agreed to be furloughed, and the employer imposes a furlough on them, well, that does give rise to potential breach of contract claims, which will only really arise in the event that the person is furloughed and paid a reduced salary in comparison with what they would normally have earned. If they're furloughed but receive their normal salary, I think the likelihood of a breach of contract claim and resignation and constructive dismissal is pretty remote. But if their pay is reduced at the same time, then I think the employer is running the risk of employee claims.
Thanks, Paul.
Was that question, or has Paul answered that question fully? I'm just checking if I heard it properly.
Yeah, so the employee has work to do at home. Is it legal for them to be asked to be furloughed? Right,
yes. Sorry, I understood it in a different way, but yeah, I wouldn't disagree with Paul.
Thanks, Carol. One particular question that's come in is this particular person is presently furloughed and has a week's holiday booked. The employer has told the individual that the holiday can go back into their holiday bank, but then their pay will be reduced to the 80%. So can they ask their employer to keep the holiday booked?
I don't see why not. I don't see why not. We shouldn't be talking about a huge amount. I mean, there's another way to look at this from the employer's perspective, is that it must be, if an employer has furloughed staff, then that is obviously because of the impact of coronavirus and a reduced requirement for employees in the workplace. If someone has requested holiday during that period, then it almost makes sense for the employer to allow them to take that holiday, because I suppose what everybody's desperate to avoid is a situation where we come out of lockdown and then people start taking lots of holiday, because that's not going to be helpful for businesses or for the economy.
I agree with that. To what extent should an employee make themselves available to contact from their employer during furlough, and is this something that should be agreed in advance?
I think the starting point on that one is that the furlough agreement and the communication that the employer sends to the employee really needs to be pretty clear that they are not to do any work during the period of furlough. The employer can set out what is expected in terms of reasonable contact from them and contactability in terms of needing to bring furlough to an end at short notice. But as long as the employer has made it clear that there is no requirement and no expectation of the individual doing any work, it's then really a matter for the individual. If they want to be logging onto their emails and seeing what has come in, then that's really a matter for them. If, however, the employer notices that the employee is doing work, replying to emails and things like that, that's something the employer really should say to them that's not what is expected of them during furlough, and that they shouldn't be doing any work.
I mean, from the employer's perspective on that, Paul, I think it's worth making the point that, again, you know, from employee relations perspective and maintaining contact, then there isn't any problem with employees choosing to maintain contacts, social contact with colleagues, keeping in touch with what's going on, as you said, you know, maybe checking on emails and whatever else. And in fact, there's good reason for that in terms of just new connection with.
Thanks, guys. I'm just conscious that it's 4 minutes to, and we've still got 57 questions left. So I'll ask you, I'll ask you another one, and then if you maybe we can start wrapping that up. So the last question is, do you still accrue benefits whilst on furlough, for example, holidays?
Yes, I think you do. I think the answer to that is you do. You're still an employee. Continuity of service will be continued. All other benefits and things like that will continue to accrue. Holidays are included in that.
I'll ask you one more then quickly, since you answered that one so fast, Paul. Can an employee later disagree to be furloughed, having initially agreed it?
I think the answer to that is, once the agreement has been reached, and so long as the employer wants them to be furloughed, no, they can't do that. But I think from the employer's perspective, you'd need to be pretty clear that you have got their agreement at the outset to be placed on furlough for whatever the duration is that's set out, either in the furlough agreement, the furlough letter, or what you've communicated to the employee. If you haven't got a crystal clear agreement that has been agreed, if you have an employee subsequently saying, well, I no longer want to be on furlough, you've then run the risk of them also saying, I didn't actually really agree to be on furloughed for any longer than this, and where's your evidence that I did? And you might run the risk there of the individual essentially claiming full salary for the period. More importantly, if they're disputing that and they do so in writing, in the event of a subsequent review by the revenue of your furlough arrangements, and the reason that the documentation needs to be kept for 5 years is so that the revenue does have a period of time afterwards to look at things if it wishes to do so. In the event that you had a subsequent review by the revenue, they could decide that that individual didn't give their consent to be furloughed for the period you wanted to furlough them for, and they could try and claw back any payment that they made to you to cover their wages.
Thanks, Paul.
Okay.
Do we have time for one last one, or shall we?
I mean, I think that's it, Georgia. We've covered off quite a lot, haven't we?
42 questions specifically. Thanks, everyone. I know there's still 57 open, so apologies for those who we didn't get to.
Okay. Well, thanks everybody for your time involved in today's webinar, and for the really great questions. I think we're going to be able to keep hold of details of the other questions. If people have got any particular queries that they want addressing that we haven't been able to do so, well, you can see we've got our details on the screen there. By all means, please do contact us. Georgia, could you flick the slide forward? I think we've got on the next page, please. We've got on the next page some details of, if you want to sign up for any of the dedicated COVID-19 insight that we are producing. And that's not just employment insight, there's also stuff from our pensions team and also from our health and safety team relating to coronavirus and COVID-19. Then you can sign up to the insight via the details that are there, and please do so. Thanks ever so much, all of you, for your time today on behalf of Georgia, Gerald, and myself. I hope you found this useful, and hope to see you, or see you at another event in due course.
Just to confirm as well, we've had quite a lot of questions about whether this will be available. I'm told that the slides will be made available to everyone after the session, and is also going to be recorded and published on the IOSH website, so you can see all our verbal answers to the questions as well. But as the guy said, please feel free to contact us. I'll just flick back to our details there if you want to note those down. We'd be happy to answer your questions. All right.
Thanks, everybody.
Thank you.
Thanks, everyone.